So here with us we have my Aunt Bonnie Boretsky. Today Bonnie's going to be talking us a little bit about her law career, and I'm going to ask her some questions about it. And so before we begin, just Bonnie, tell us a little bit about where you studied law specifically and what your law career looked like.
Okay. Hi, Dana, and everybody who's listening, and thank you very much for this great opportunity. I started law school in 1976 at the University of Ottawa, where I was studying droit civil in French, actually, the first time I studied full-time in French. And I did 3 years of law school and graduated in 1979 with a civil law degree. And then I did bar school right after. At the time, Quebec Bar School was offered at the University of Ottawa. And my same classmates, some of them at least, were in a class with me. We went to school from September to April. And then in 1980, I was 23 years old, and I didn't really want to start working. So I actually, at the University of Ottawa, was ultimately able to finish also in 1 year a common law degree. So I didn't do a 4-year program where I got 2 law degrees. I did a 3-year law degree for common law, and then I did a 4th year
With the bar
with the bar in between. And then I became also I got a common law degree, so I have 2 law degrees. I ultimately went back to Montreal after that and practiced in Montreal and got called to the Quebec bar. I never got called to the Ontario or any other provincial bar. It served me, but I didn't really need, and all the pleadings that I was doing was an administrative court, so I needed only to belong to a Canadian bar. Any bar, it didn't matter which bar I was a member of.
What does that mean to be called to a bar?
Called to a bar means you have the right to practice in the courts of each province. So each province has its own bar, law society or barreau in Quebec, and they call it the bar. So each province has its own. So in order to plead in court in the Quebec courts, you have to be a member of the Quebec bar. There's reciprocity between different provinces, and oftentimes lawyers will get temporary permission to go argue a case in the Yukon because they'll have a lawyer from Toronto to go argue a case up. But if you're practicing in an administrative tribunal, like I did in labor law, then it didn't matter which provincial bar you were a member of.
Okay.
So it never, in the end, affected my career by not being a member of the Ontario bar. So I articled in Montreal for a small law firm and did all kinds of different work, including a little bit of labor law for one labor lawyer who worked at that law firm. There weren't even 10 lawyers at that law firm. And probably the most fun I had was working for this one guy in labor law. I did a little bit of everything: wills, immigration, contracts. But labor, I already knew I liked labor law, but I didn't really know that for sure I was going to practice in labor law. So I started to practice a little bit there with him, and it was through him that I met the next guy who was going to hire me. And they were both named Harold, oddly. So the first Harold I worked for was representing trucking companies. The other Harold I worked for was representing the unions that represent truck drivers, which was the Teamsters. So when I went to work for the second Harold, I was representing Teamster members. So I worked for that law firm for about 1.5 years, and then in the end they changed partners and I lost my job basically in 1983. And then I'm going to spare you many of the details. I actually I continued some work on a master's that I had started previously, and that's when your Uncle Andrew and I moved to Ottawa, actually, so I could finish that master's degree, which I never did.
At U of O?
Yes.
Got it.
I never finished it. I ended up not wanting to write it, and I ended up working for a union on a temporary assignment as a grievance officer that was preparing grievances for the Canadian Union of Public Employees, CUPE.
What's a grievance officer?
A grievance officer is when under labor law, there's, in a unionized setting, there's a collective agreement. That's the contract between the union and the employer that sets out all the terms and conditions of employment for the union members, the employees of the employer, of the company. And if the employee thinks that anything was misapplied or inappropriately applied, they have the right to complain, called a grievance, under the collective agreement. And there's a process for agreements to be heard inside of the collective agreement that ultimately, if it can't be resolved between the parties, goes to in front of a third party arbitrator. So when it goes to arbitration, oftentimes, used to be most times, I don't think that's true anymore, oftentimes the lawyer represents you. So I would be, as the grievance officer in the union, working with the employee and with the lawyer and preparing a case to go to arbitration. That was really the job of the grievance officer.
Got
Ultimately, the union wanted to offer me a job in New Brunswick.
Mm-hmm.
At the same time, I was still trying to find work as a lawyer, because here I was working as a grievance officer, is a little bit overqualified to be a grievance officer,
Okay.
but I was glad to have
So it's
work.
not technically lawyer.
Yeah, not always. Sometimes it could be, but it wasn't where I wanted to end up. And I ended up getting a job offer at the same time as I had this offer to go to Fredericton to open up a union office for QP, an offer from Canada Post, and that was the fall of 1984, and I retired from Canada, which that was the job I took.
Yeah.
For a variety of reasons that you may or may not want to know, but it doesn't really matter. Partly that I wanted to stay in Ottawa, so that was one of the drivers. And then 31 or 32 years later, I retired as the general counsel of Canada Post. So I had my whole career, all the rest of my career at Canada Post.
And what were you doing at Canada Post?
Canada Post, I was working I started working as a labor lawyer. So I was arguing arbitration cases that I just mentioned.
Yeah.
There was a whole department of labor relations that had people across the country, and labor relations officers would be arguing the grievances that employees would file through the process set out by our collective agreement. And when they couldn't resolve it, it would go to arbitration, and the lawyers, like me and 20 other lawyers in the company, would be arguing those cases in front of different arbitrators all across the country. So I got to travel Canada and see a lot of the country before I stopped arguing those cases. And I did a lot of them in Quebec. I actually pleaded a lot of cases in French, which was one of the reasons why they hired me.
Because you were bilingual.
Yeah.
And then, so at this point, you're now arguing on the side of the employer.
Exactly.
Okay, cool.
Exactly.
Great. So within all of those cases, you worked for a while. Was there anything particularly interesting, like a particular case that stands out to you that you want to tell me about?
Well, I wouldn't say a particular case so much as a particular situation, and that was a pretty recent one towards the end of my career when I was already the general counsel. So I was the lawyer in charge of 25 lawyers across the country. I had also a security under my responsibility, compliance areas. But this was a very hands-on experience for me where we had a big strike for one of our unions, probably our second to smallest or smallest union. We only had 4 different unions, but this union struck close to Christmas time in the middle of the winter. Ottawa actually also happened to have a bus strike, but this was across the country. And they succeeded in shutting down the plants, almost shutting down, slowing traffic so we couldn't get into the plant. So even though these guys did not work with the mail, they were an administrative bargaining unit, they were able to almost stop all mail from being delivered. Because if you block access to one of our postal plants, like in Montreal, right, the big plants.
Like physically block access?
When you have a strike, you're allowed to slow down the traffic. You're not allowed to block it, but you're allowed to slow down the traffic and have an information picket and explain your position to whoever's coming and going.
Mm-hmm.
You can't stop people from going. You can't be violent. You can't threaten life and limb, but you have the right to have an information picket and explain your position. So if every car gets 2 minutes, that doesn't take a lot of time for a big bunch of cars to pile up into the street and stuff. We had these situations across the country, and we were arguing across the country, getting injunctions to manage. We couldn't stop the pickets because it's the legal right to picket if you're in a legal position to strike. But we were able to manage the picket line so that cars had to pass every however many seconds, and that many cars would have to go in a certain amount of time and let the mail get through. And we were able to maintain postal delivery for the whole country in that time. And we were coordinating at the head office where we had a little bit of a war room. It wasn't really a war room, but we did have sort of a situation room, I would guess we would have called it. And we were managing, we had lawyers from our head office team that were all out across the country, and twice a day in the morning and in the evenings, we were talking about strategy, who was going to court, what they were arguing, the settlements they were getting. And so it was a big puzzle. It was a very intense time. Nerves were high. People were out on streets in the cold in the winter in December, closing in on Christmas, our highest mail volumes, a lot of pressure, a lot of excitement, and we were very, very successful in managing to keep the mail moving the whole time. And so it was a very, very gratifying experience. Very nerve-wracking and very intense, but very gratifying.
That's so cool.
Mm-hmm.
And even though, like, that becomes your job, even as a lawyer, like, wouldn't you be only working on things that happen in court?
Well, we were getting injunctions in front of a court, so we would go to a court.
And that's what allowed you to manage
outside
this.
count. Yeah, exactly.
Got it.
So we were doing our lawyers were on the floor getting affidavits, getting statements getting facts, getting plans of the streets where the plant sits, and then they would give it to outside counsel that we hired. So I was managing those relationships, and then we had people going to courts and arguing on the footsteps. Most of these things get settled. Most of the things don't get to a judge. Usually the parties can agree because they know what the judge is going to say, and then we get an agreement that gets signed by the judge, so it has the effect of a decision, and we would be able to enforce it. Because then, if you don't respect an injunction that's been signed by a court, then you're accused. You could be charged of contempt of court, which entails jail sentences and fines. So it's a pretty serious situation that we were.
That's crazy.
In front of. Yeah.
Because also something we were talking about in our law class was that, like, the machine of justice is slow. Like, we all had to go watch court cases, and we noticed how much time everything took. But it sounds like this was pretty quick. Like, how many weeks was this?
So it was not very long. You're absolutely right. And when in order to get to facilitate injunctions, you get to judges very quickly because it is a very intense and so they have judges who are usually set aside for emergency motions and applications like an injunctive relief. You're absolutely right. This doesn't follow the normal process.
Yeah.
You don't file an application. You file an application, but you could be in court the next day.
That's so cool.
Generally speaking, yeah.
Okay, cool, great.
Because they're called, I think they're, I forget now, but they're temporary injunctions. They're limited time.
Because it's like really affecting people.
Yeah, exactly, and it's only lasts for 10 days, and then it could be continued, but it's an interim relief. It's an interim injunction, and so that's another reason that you could do it. So that it's allowed to go so quickly because it's not going to be a final decision for all time.
Okay.
Right. So it's going to be reviewed.
Okay.
And hopefully the parties will settle. In this situation, especially, the parties settle generally before they expire.
Okay.
Mm-hmm.
Cool.
Yeah.
And then my next question is, do you ever feel like you were treated differently, or like there was a different experience for you as a female lawyer, especially in a time where like women were getting their grounds in professional fields?
Yeah. So I being in law school in 1976, I didn't feel like I never felt like I was a pioneer of the women's movement.
Yeah.
I felt I was really that the brush had been cleared from the path for me, and that I felt like I had smooth sailing. A third of my classmates, I would say, were female. So I know now it's probably half or more. So it has evolved for sure since I was there. I'm going to say that. So I did not feel in law school, and as a young lawyer, I did not feel funny. I never felt anything about being a woman.
Yeah.
I never felt discrimination for any of those reasons either when I was working. But as I was becoming a senior member of the executive of the company, so because while I was growing up as a lawyer, I was also growing up as an in-house counsel. You grow up sort of as a business person as well, and the further you get in your career, you need to understand the business. You need to understand how the lawyers are helping the business, and so you become an executive of the company. And when I was a younger woman, and earlier on, I'm going to say this was in the late 80s and early 90s, oftentimes I would be the only woman at a table in an office in a room with people. So there was for sure, and I was probably on the younger side also. So being young and then being the only female. There were senior executive women who were ahead of me for sure, but not a lot. Like we knew them, right? There were two or three of them, and so I would have known them. 2 or 3 out of, let's say, 20 senior people. When I got to be at that level, we were many, many more women. But there were often times where I would be at an overnight event with being the only woman out of 20 men or 30 men. So, but it occurred to me because you would look around the room and you're thinking, oh, like there's nobody to go to the bathroom with. But then other than that, no, it was never posed, it never felt like a problem for me. never felt like a challenge.
I do feel like that's, I mean, maybe not right now, but that is how it started, with much more women in like the actual workforce, but then people running it and the executives like higher up.
Exactly.
Not yet.
Yeah. Exactly.
And I know that like people of color are still dealing with those kinds of things.
100%. 100%. Yeah. And on the board that I'm on, it's still an issue. We're half women. We're keeping those numbers up, but for in terms of people of color, people with disabilities, so those are still challenges to make sure that there's diversity.
Yeah.
At senior levels for sure.
Cool. Yeah, so this class is also about the morality and the ethics of law specifically. And I just want to talk about the kind of irony of originally representing the employee and then representing the employer. Like, how do you deal with that idea as a lawyer, and how is that, like, okay in the system of law?
Well, a lawyer always has to represent their clients, number one. But generally speaking, your intuition is right that generally speaking, a lawyer in labor law will be either a lawyer for an employee / union or for the employer, and only one at a time. So you wouldn't be in a law firm and represent both sides.
And does that tend to correlate with like political views usually? Or is it just where you end up being placed?
It depends on how strongly you feel where you want to work. So
Yeah.
I wouldn't say really it's politics, it's your own personal bent.
Yeah.
But then your own personal values and principles also have to meet with the reality of getting a job. So I was faced with 2 job offers, one with the union. And when I first started, I did want to work for unions.
Yeah.
And that's probably appropriate for my age, that was what I wanted to do. And then when I was faced with getting a job, I could have continued to work for a union and moved to New Brunswick and far away from my family and my husband's family, or I could stay here and work for a national company, and which seemed like a great job for me as well. So I took what I thought was the right thing for my life at the time, which was to stay in Ottawa. Yeah. And so did I think I was giving something up? I probably did think I was maybe putting a little bit of water in my wine. I thought, I'm giving up already on my principle of helping employees. But then I thought, well, I'm going to be working for a big major employer in Canada where there's 60,000 employees, so this was going to have a big impact. If you could be part of a management team and be part of a solving problems, that labor relation problems that a company has, and you can help the company be a good employer, well, that's helping employees.
Of course.
So now everybody has to rationalize what they do in life, but I do think that in terms of the morality of it, I didn't think that I was completely giving up on everything.
Yeah, no, I hear what you're saying.
So that's how it was in my head anyways.
And when you were originally working on the union side, did you ever imagine that you would be
on the other side?
Yeah.
No, I never really was looking that far. I wasn't really planning my career so much, and so no, I was where I was. But I'll tell you, a very hard thing was for me as a young lawyer. I was a very young lawyer. I was in my late 20s.
Yeah.
26, 27. And I have a trucker who lost his job, is sitting in my office, and I'm going to represent him and try to get him his job back. And he's explaining the situation. I'm preparing him to testify at a hearing. That was a lot of pressure on me to try to get his job back, and that was a very emotional time for him, and tears. And he was like this adult man whose job was on the line, who lost his job, was fired, and I'm trying to get his job back. That was very, 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 very hard.
I'm sure.
Very hard. And so this was going to the other side was in some ways much easier for me, because if we were going to lose a case, well, it's a big company, it's not nobody's losing their job because I'm getting it wrong.
For sure.
So it was very, very different. It was very different. So that was a very hard moment for me, that afternoon in my office. I was very distraught.
And also because it's a smaller law firm, right? So you're
absolutely. It was a smaller, and we were representing a small trucking company, but nonetheless, it's a guy's job.
Yeah.
His livelihood.
And do you find that there's more, kind of like more of a system in place when you're working for a bigger company, like more things that go in between you and the people you're working with?
Well, when you come down to it, when it comes to these kind of grievance arbitrations, at the end of the day, if there's a dispute that goes to arbitration, you have the employee and his lawyer or her lawyer, you have the representative of the company, whether it's a supervisor or a manager or a dispatcher, whatever the person is, and their lawyer, which would have been me when I was working for Canada Post. And that's it. It's 4 people or 6 people in a room with an arbitrator. So all of right, and there's a collective agreement
No matter
between
the
both
size.
parties, whether it's a big collective agreement that covers 60,000 employees or 50,000 employees or 12 truckers in a small trucking company. It's all the same rules. It's vacation leave, it's overtime, it's all the same problems, and all of that is the same. The framework is completely the same. So yes, you're right in some day to day, but when certain things came down to brass tacks, it didn't really matter. It really didn't matter.
So it was like the same training for both sides.
100%. 100%. The bigger the company, the more ins and outs you have to figure out. The small p politics of a company and who you talk to, how things work, how the culture of a company you have to get to know. So absolutely, in a small trucking company, that wasn't a thing. And also, when I was working in private practice, I was representing many different companies. It wasn't only one. So you didn't get to know people the same way. It was very, very different. Also.
Yeah, is that also part of when you're going from one side of the debate to the other? Are you like using your information and the arguments you made for the employees to help your arguments for the employers?
Well, you learned certain things, but always as a lawyer, I think you have learned to. Yeah, I mean, you read all the case law. You know which argument is going to work and which argument is not going to work, and you know how to refute both sides. So it doesn't really matter who you're arguing for. You always have to be right. You're always able to argue both sides.
Yeah.
And you'll always convince yourself that yours is the better case.
Okay, I think we're done. Thank you so much, Bonnie.
My absolute pleasure.
Thank you for teaching us about labor law, and it was really nice speaking to you.
Likewise, Dana. Good luck with school.